Good afternoon. Paul Vincent is my name, and I'm here to deliver a paper to you and a discussion on how to resolve commercial disputes. You have before you a slide presentation that I'll run through and discuss briefly the paper that is also attached to this webinar. You'll see the document attached to the webinar. I'd recommend you download that at some stage after today, if you haven't already, and have a read of it, because it contains far more detail than the material that I'm going to deal with in the next half hour. So without any hesitation, let's move on. Commercial disputes. I thought I'd give a little summary up the front of the discussion. Most disputes are settled before any litigation starts. So these are the disputes that we normally get involved in. You yourself would get involved in many disputes. Disputes with clients about fees, disputes with suppliers about their charges, disputes with government departments, disputes with your neighbour, disputes with your children. The list goes on. The primary goal of any dispute is obviously to have it resolved. The earlier the better, generally. But one thing's certain, all disputes do get resolved. So most of them get resolved before any litigation starts, which is a good thing. After litigation commences, then another big chunk of disputes get settled. So it's only about 2% of disputes that end up going the full distance to court. With the exception of only a few instances, money is what fixes disputes. Most disputes are either about money or where money is the best means of resolving those disputes. Of course, if there's a contractual dispute between parties and someone hasn't fulfilled their part of a contract, sometimes the contracting party will breach the contract rather than complete it, and be quite happy to pay damages rather than perform their obligations under the contract. So generally money will fix most disputes. So let's quickly go into the types of disputes that we are confronted with, and there's really only 4 classes of disputes that you will see and you'll be confronted with. The first type of dispute is a dispute in principle, or dispute on principles. And I use here an example of the case of the unhappy vet. Let's assume Jane runs a vet clinic in a small country town and has just sacked her assistant, Wayne, because she's discovered that Wayne's been using a leather strap to discipline animals. Jane doesn't tolerate any cruelty to animals, and once she discovered Wayne's mistreating the animals, she immediately sacked him. Wayne is suing for unfair dismissal and he wants his job back. Now, this is a matter of principle. Jane will not work for anyone she believes to be cruel to animals, and Wayne is unlikely to change his behaviour. The question of reinstatement is not negotiable for Jane. If Wayne insists on seeking reinstatement, then this matter will need to go to court, or in this case the Industrial Commission. In disputes where conflicting principles are at issue, the court's the best means of resolution. They're the most lucrative for lawyers and forensic accountants, I might add, because they very rarely get resolved. Of course, if Wayne chooses not to press for reinstatement, it would be a different story, and then money might fix Wayne's problem. Second type of dispute is a dispute in law or legal interpretation. I use a case of a confusing contract. And many of you have seen contracts where the drafting of the contract is such that there is some confusion in law or in some legal interpretation of a clause in that contract where there are differing views. Now, those disputes are pretty hard to resolve, and I suggest that where you have a difference in legal opinion, it might well be that those matters need to be heard by a court, unless, of course, some negotiation can take place to resolve those disputes. There's disputes that actually require compromise, and compromise is something that inevitably resolves most disputes. I use a case here called Jane and the Big Bank, where Jane's son has borrowed some money and used Jane's house as a security for the loan, and the son has shot through, left the loans unpaid, and left Jane's house exposed to the bank as a third-party mortgagee. The bank doesn't like taking possession and selling old people's homes, and so in many instances there is a degree of compromise that might come from this. So this is unlikely to go to court, this type of dispute. It will be a result of a compromise by both the bank and by Jane, so that, as I say in my slide, so that neither of them are happy, but they both have compromise. Then, of course, there's the win-lose disputes. This is where there's a clear winner and a clear loser in a dispute. And I use a case here called the fight for the last kidney. And it deals with, I suppose, there's two people who are on a waiting list for a kidney, and one person is, although ahead of the list, at the top of the list might be, and a kidney is presented as from a donor. There might be circumstances where someone further down the list who probably has a shorter life expectation may well end up with a better case for a fight for that last kidney. This is something that will not be resolved by negotiation. It will not be resolved by any form of compromise. There's one kidney, so someone will win and someone will lose. Now, obviously, in this particular case, there are specific guidelines that every hospital has and the medical system has with respect to donor organs. But there are many cases in commerce where there is a winner and there's a loser. And they're the ones that have to be heard by a court or a third party, because it's unlikely that these two can sit down and have a reasonable discussion for a compromise to resolve the dispute. So, dealing them, we have 4 types of disputes. And it's not impossible that they can all be resolved without going to court or without going to some form of litigation. But you've got to understand the type of dispute before you can attempt to try and resolve it. And regardless of what type of dispute it is, these are the sort of disputes that we currently get involved with on a daily basis. But the list is way more than this. Insurance claims, family law disputes, trade practice disputes, fair trading disputes, presumption claims, industrial law, partnership disputes, shareholder disputes, the list goes on. And all these disputes need to be resolved. Let's talk firstly about how we avoid these disputes. And from a professional perspective, if you're giving advice, if you're providing services to anybody, firstly, don't do anything you're not qualified to do. Try and limit your liability contractually. obtain adequate insurance, just in case. Limit your liability structurally, so having the proper corporate structures involved that actually limit your exposure to any legal action. Understand the legal environment in which you operate. Records are key in disputes. Keep proper records. Obviously maintain honesty and integrity. Be prepared for disputes. Identify where your high risks are when doing business, and looking at the consequences of a dispute arising, and be prepared for any of those consequences. Maintain a regular training program for staff, and keep an eye on things regularly. Perform regular reviews. Obviously, the plan would be to avoid disputes. But if you can't avoid disputes, then we've got to resolve them. And there's some general steps, and there's no misprint in here. You review your case, assess the loss, gather and preserve evidence, attempt to negotiate a resolution. Be willing to compromise. Assess the other side's ability to pay. That's an important one. Attempt to negotiate a resolution. That's the second time that appears on the slide. Assess the cost to proceed and the likely success. Further consider a compromise. Again, more compromise and settlement options. And then, if all else fails, proceed to litigation or court, or abandon the claim. That's sort of the options you have, and this is where the crux of this discussion today is going to reside. The options you have to resolve disputes are all listed on the screen now. You can negotiate, you can mediate, you can arbitrate, or you can go down the litigation path. I want to talk about these in a little more detail. Let's firstly talk about negotiations. Negotiation should be your first port of call when trying to resolve a dispute. Let's look at a case, for instance, where you might be having a dispute with a client regarding fees. Now, I can tell you from first-hand experience, it's worth doing the steps that I set out earlier, and assess your loss, review your case, and determine the extent to which your case has strength. Many instances, and I've seen many instances where people have sued for fees or unpaid fees, and as a result of not negotiating a reasonable settlement, has cost them a fortune. So you can negotiate with or without third-party involvement. And what I mean by that is, let's say your client rings you, or someone has a dispute with you, and you go, okay, I can negotiate with you, I won't, I don't need any advice. The dispute's over a $20,000 sum, let's negotiate a settlement for $15,000. And between the two of you, you can do that pretty reasonably. There are, though, instances where a negotiation can take place. However, you do need third-party advice. You do need to have input from others, legal opinion and accounting or expert evident opinion on quantum, so that you can work out what you should negotiate or how you should negotiate the dispute. And whilst I'm a huge advocate for early resolution, I've seen many early resolutions occur where the parties, one or other of the parties, have resolved the dispute that in a manner that is not favourable to them had they properly assessed their case or had they properly assessed their loss. So it's important to properly assess what it is you're fighting over first before you go to the negotiating table. So that means proper advice from lawyers, proper advice from those that know how to determine and calculate loss, so that when you go to the negotiating table, you come from a position of knowledge, not necessarily a position of strength, because it might be that your case is not that strong. But you need to know that before you go to the negotiating table. There's also negotiate using financial dispute resolution, which is similar to getting a mediator involved, but this is essentially a third party who has financial understanding and who can bring some financial common sense to the dispute and basically bang heads together so that the dispute gets resolved. The next means of resolving a dispute is by means of mediation. Now, you'll hear lots about mediation, and it's becoming more and more prevalent in commerce now, because in many instances the courts now require a compulsory mediation conference or a court-ordered mediation before a matter even gets a chance to proceed to trial. So I wouldn't mind focusing a little bit on what is mediation, because it's important to understand the mediation process. One of the underlying philosophies of mediation is that the parties can reach a settlement that doesn't necessarily conform with legal precedent or to community standards. It's one which resolves the problem to the satisfaction of the parties. So it's a result that is in the control of the parties. And that's pretty important in a lot of disputes, is to try and maintain some control over the result. And the mediation process allows you to have some control over that result. Mediation, it's also good because it's informal. It's usually successful. Mediators don't like leaving a mediation without a settlement, so they do tend to be encouraging of a settlement, and good mediators will generally find a way to settle. They certainly can reduce legal and other costs. They can also help a relationship survive because it's a private affair and never a public record. So you can say, right, well, we'll resolve it this way. Let's agree to this solution, and we'll go about our business, and forget about the past. And that negotiation and that mediation process is always private. And even if it doesn't settle, it will narrow the issues that are in dispute. So it might be that the dispute might be over a number of issues, and there might be a number of issues, for instance, that contribute to the loss or to the damages you're seeking. What the mediation will do is it will focus on the issues that are in dispute, and it will narrow them, so that even if it doesn't resolve, by the time you get to court or the next step in the litigation or the resolution process, you've narrowed the issues to only a few rather than the many. The mediator is neutral, and it's the party's solution. Again, controlling the result. You're part of the result. It also encourages discussion, and everything you do at a mediation is without prejudice, which means it can't be used or brought up as evidence in a subsequent trial. So mediation is something that I encourage you to find out more of and to be actively pursuing before going to the next step. another form of resolution is an arbitration. Again, an arbitration is often called an adjudication. It is a private trial-like process that can be commenced by any two or more parties who agree to arbitrate their dispute, either under the terms of a contract or by legislation or by simple written agreement. And what happens is an arbitrator, what happens in the process is it's like a private trial. It's brought on by terms written into an agreement generally, and arbitrators are usually experts in the field in which the dispute arises. So if it is a dispute in engineering, is generally an arbitrator is generally someone who knows a lot about engineering. If it's a financial matter, it's generally a financial person, and so on. And that is to reduce the time required to actually educate the arbitrator. Sometimes there's a panel of arbitrators, depending on the size of the dispute. And the arbitrations operate under the Commercial Arbitration Acts, giving arbitrators most powers and authority that a Supreme Court judge has. In an arbitration, the parties and the arbitrator determine the degree of formality required. So it can be a formal process, or it can be informal, but that is determined, again, between the parties and the arbitrator. And an arbitration can deal efficiently with a range of disputes. And another benefit of the arbitration is, in fact, it's also confidential. Of course, if all else fails, you can't negotiate a settlement for whatever reason because of the nature of the dispute. You can't mediate the settlement, and you've chosen not to go to an arbitrator when you've received a court, then what happens then is you've taken out of your control essentially any control over the result. In a trial or a court, once the matter proceeds to court in Australia, the court is an adversarial process, which simply means the plaintiff brings the evidence to prove the case, and the defendant brings the evidence to disprove the plaintiff's case, and that's brought before an independent hearer of fact, a judge, who is essentially a layperson. So the interesting thing about that process is that you think to yourself, how can this layperson, this judge, get to the truth, get to the real answer in a trial? Well, that's not what it's about, sadly, about court. It's all about evidence. So all the judge has to deal with is the evidence that's before it and before the court. So if a plaintiff brings really strong evidence and its legal team bring really strong evidence to convince the court of their position, and the defendant brings insufficient evidence to disprove the plaintiff's case, then the plaintiffs may well win the case, and vice versa. Is that the correct result? Well, it depends on the evidence and how the evidence falls, and the strength and weight that the judge, the weight the judge and the court place on the evidence. The issue with having a trial and going to court is that the matter is public. So it's in the news sometimes if it's newsworthy. Otherwise, it's on the court list, and the material that you file is all available to the public. So, you know, that could be an issue for some matters. It's structured and formal. So that's the process that you're going to be involved in court. The judges are lay people, and the lawyers and barristers are advocates for their clients. So again, they are there to present evidence on behalf of their clients. And it's the strength of that evidence that determines the result of the case. And someone will ask, you know, what is the result of that case? You know, did we get to the truth? Did we get to the right answer? The judges will nearly always get it right based on the evidence. It's the evidence that determines the result. So if you lose a case, it's because the evidence you brought was insufficient to prove it. And so, you know, that's the risk you run when you're going to court. I just want you to understand that the court process is a very costly process in many instances, and if you are serious about going to court to resolve your dispute, I would recommend that you think very carefully about the quality of the evidence you have, the quality of the lawyers you engage, and the quality of the barristers or counsel you engage, because they make a huge bearing. They have a huge bearing on the results of the case. So I'd only proceed to trial if you really seriously want to commit commit funds to a result. So my half an hour is up. I want to go back to what I said originally, and that the majority of matters that are filed in court are never determined by the court. They'll be settled way before the trial. And a majority of disputes are settled way before the litigation starts. My recommendation to you in dealing with commercial disputes is protect yourself from them in the first place and avoid them as best you can. But if you do get involved in a commercial dispute, be very, very keen to look at resolving it as early as possible. And to do that, you need proper advice. You need proper legal advice and proper advice on the losses you may have suffered as a result of the dispute you're involved in. And once those are determined early in the matter, you'll be in a far better position to negotiate or resolve your dispute. So the paper I've included in this discussion is worth having a read of. It goes into a bit more detail, and I thank you for your attendance.